Okay, folks, before we start, we're going to do so are you ready? My suggestion is that maybe we take him for today and let's just put him back on for the I think that we help on back on for the 13th. People in the Department of Corrections custody, I think Mr. Stillwell is like flipping down there. We're going to put those people back on. That's my regular side things on the 13th. That's the time maybe we go out and talk and then go some and save some of those issues and some of them might be so just want to let you know that's the kind of reason for the company waiting. I was going to do my ass to see if it could rain and get to it and whatever we should do. That's what the deal says. Okay, and I acknowledge that you have one of the cooperating witnesses in your statements to our clients, and just on behalf of Stillwell, also that in his absence, I raise his presence to the purpose of making this objection. But we too feel that Mr. Allen, the attorneys, from discussing the statements of cooperating witnesses till the end of November, and with the trial we anticipate that the statements of cooperating witnesses may be the crux of this case, and obviously, a lot of the information that is pertinent in drafting a defense and coming up with a defense is, involves input from our clients. So, we would also object to, and of course, we're going to abide by the court's order, but we would object to, that delay in being allowed to discuss the evidence against our clients openly.
Well, you need to be more particular, it's confidential information, okay? It's not just there'll be other things you can talk with your client about, but, this is particularized to, issues involving, confidential other information.
Right, the cooperating witnesses.
Yes.
Yes.
All right. Anything else, sir?
No, that's it for today.
Okay, all right, your objection's been noted for the record.
Thank you, Your Honor.
Okay, all right. All right, so, Mr. Chamberlain, where are you, sir?
I'm right here, Judge.
Sir, I'm gonna put Mr. Stillwell, number 14, on for the 15th of October, okay?
13th, Judge.
13th, you're correct, sir, the 13th.
Yes. Okay.
All right, thank you.
You welcome.
All right,
Mayor,
sure.
that was the only other matter that Mrs. Steele and I had in regards to Mr. Williams. And of course, we waived his presence earlier.
Yes, sir, did you wish to remain, or you're welcome to do so, or would you like for the court to excuse you?
I'm asking for the court to excuse me. I'll probably go back to my office and maybe chime in.
You're welcome to do so. Yes, sir.
Thank you.
Okay, all right. Ms. Sharp, you're excused as well, sir. Thank you. Okay, all right. All right, okay. Ms. Merchant, thank you to begin with for your patience with us. To begin with, and let me go ahead, and you have several motions, but can I deal with the issues involving the motion to dismiss and plea and bar, and then the double jeopardy issue?
Yes, Judge.
Okay, and then I'll transition into the motion to sever, and I'll let you and the others who are here, who have severance issues they want to talk to me about, go ahead and do that at that time.
And we're happy to hold on the severance issues. We were given some additional discovery by the state on Friday, which I think bears to the severance issues. It was the discovery for the new indictment. So
Okay.
we've never seen that up until last Friday. I've worked through it, but there's hundreds of hours of videos, and there's been 2 business days this week since I've had it, and I haven't gotten through that, so on the
Yeah.
severance.
I will let you defer that until a later time then.
Great.
Okay, all right. But, okay, so let's take up, so we'll table that one, your motion to sever, I'll let the others decide accordingly whether that they would like to do so as well. But go ahead and let's talk about your motion to dismiss, based on statute of limitations and the double jeopardy issue.
And Judge, where would you like me to be tomorrow?
Any place is fine.
Okay.
On the main table, you can sit down, you can come and vote, whatever your pleasure.
Thank you. I know that courtroom logistics have changed somewhat.
Yes, ma'am.
Just wanted to ask.
Okay.
Thank you, Judge. So we filed 2 motions. One of them is based on the statute of limitations, and one of them is based on double jeopardy. I filed them under the old indictment, and then there was a new indictment, so that added some other counts. So the argument is somewhat different because of those new counts. but I want to focus on the two predicate acts that were alleged in the indictment that we believe are barred by double jeopardy in the statute.
And just to clarify, I did sign an order authorizing the current motions that were filed under the old indictment to be reincorporated in the new indictment ending in 572. So to perfect your motions and argument, we've already, they will pertain to this indictment. Anything else you add, okay?
Thank you, Judge.
Okay.
So there's really two incidents that I want to focus on, and I want to just talk a little bit about the facts first because I think that's helpful. My client was first arrested in a case that is alleged in Act number 11. So in the indictment, the new indictment is on page 17. It is Act number 11. It's alleged to have occurred on September 18th of 2014. That count says that as an associate of YSL, he committed a felony and aggravated assault with a deadly weapon against a person named Michael Castellini. And that is an act of racketeering activity and an overt act. So they're alleging that it's an act of racketeering and it's also an overt act. That case, the aggravated assault was dismissed, it was null-crossed, and my client pled guilty to a reckless conduct. He received 12 months probation on that case. That was in 14 SC 131032. And again, the aggravated assault was null-crossed, and he was convicted and adjudicated guilty on lesser included on count 3 of reckless conduct and received and successfully completed 12 months probation. The firearm charge was also null-crossed. Moving forward, he is charged then on page 22 of the indictment. He's charged in Act number 29, along with a couple other folks. That act is not alleged to have been a crime. That is only alleged to be an overt act. So that's not one of the ones that we're arguing about double jeopardy pertaining to, because that's not actually a crime. But if you fast forward to page 30, acts number 56, 57, 59 are all part of an action that happened on October 1st, 2015. That case was a conspiracy to commit murder, a theft by receiving stolen property, a firearm, and a street gang participation. My client is currently under first offender probation for that case. He was charged by the same district attorney's office, and he was granted a plea bargain under the First Offender Act, and he is still on first offender probation. My client is then charged with another overt act, but that is not alleged to be a crime, on page 40, number 97. Also on page 43, number 111, he's charged with a photo. That's another overt act, again, not a crime, not a criminal act specifically. And then page 48, he's charged in 131 and 132 with additional overt acts, not crimes, about a YouTube video and a conversation. So those are essentially the crimes that he's charged with up until the May 9th case. The two underlying cases, the 2014 and 2015 case, both of which he pled guilty and was sentenced for, we are alleging one should not be allowed to be used as predicate acts in furtherance of racketeering activity, and two should be barred by the statute of limitations. So it's a little bit, our argument has shifted a little bit because now they have indicted him on additional counts that happened in 2022. So while I will agree that takes the racketeering act outside of the statute of limitations issue, the two predicate acts that they've alleged, the ones that we've outlined, the two I'm talking about, when I'm talking about those, I'm talking about the 2014 and the 2015. Those two crimes, those two cases that he's got probation for. We do not believe that those should be allowed to be charged as predicate acts, and that those should not be allowed to suffice as two of the crimes that have to be proven for a racketeering case. And what he's charged with, if you look back at the statute, Judge, he's charged with 16-14-4. That statute says that through a it's unlawful to do an act through a pattern of racketeering activity. It says you have to have, and then the definition section of that statute is 16-14-3. It says a pattern of racketeering activity, this is subsection 4A, says engaging in at least 2 acts of racketeering activity, and that the last of such acts occurred within 4 years. It then goes on under 5A to define what racketeering activity means. And it means to commit any crime which is chargeable by indictment. To commit, solicit, coerce, or intimidate another person to commit a crime which is chargeable by indictment. So essentially what they're doing is they're using 2 criminal acts, which he's already pled guilty for and was sentenced, and which are also outside of the statute of limitations, as the 2 predicate acts to bring him under the Rico statute. These are different than the overt acts. There's overt acts that they can still argue these overt acts are somehow relevant, but that's not what our issue is. Our issue is these 2 criminal acts that happened 9 years ago, 8, 9 years ago, for which he has pled guilty and sentenced. And if you think about it, what's going to happen if this is allowed to continue is in front of the jury's going to hear he's pled guilty and was sentenced to these acts and is on probation. So they've already got an admission. He's actually under sentence currently on one of them. And so there's a lot of different case law I did want to address because the state addressed it in their response brief we received yesterday. And I did just want to address briefly, I'm not going to bore the court with double jeopardy case law because I know the court is well aware of what the case law is, but the state had made some contentions in their brief that we had somehow misrepresented what the current state of the law is. Judge, I would just refer the court to the 2021 case of Maxwell versus State. That is probably the most recent double jeopardy case out of our Supreme Court. That case specifically cites the cases that I've cited in our motion.
What's the citation for Maxwell versus?
Yes, Judge. It is 311 Georgia 673, and it was decided June 1st, 2021. And at the time, Chief Justice Melton found it important to cite the same cases that I cited in our motion that the state has said it was improper somehow for me to cite. On page, in that opinion, they cite Estevez, which Estevez was overturned as far as whether we use the required or actual evidence test. Yes, but they cite the exact statement of law that I cited in my argument. And I think that case, that Maxwell case, is really the most instructive. And it talks about procedural double jeopardy and the factors that must be satisfied. The factors that it talks about that must be satisfied are if a second prosecution is barred, if the crimes could have been brought in the first prosecution, that this constitutional double jeopardy protection is enhanced by Georgia's statutory double jeopardy protections, and that we have an additional double jeopardy protection here in the state of Georgia. Unlike constitutional double jeopardy, Georgia's statutory procedural double jeopardy extends the concept of res judicata to the successive prosecution of different crimes arising from the same conduct in situations where the state should have prosecuted the different crimes in a single proceeding. These were all the three things that are required. They were all known by the prosecutor at the time. And they could have been all charged in the same action. So if they had wanted to charge him with conspiracy when they charged him with the 2015 case or 2014 case, they could have. There's no additional discovery on those crimes. There's no additional information that wasn't known to them then. And so, Judge, it's just our argument that that they're outside of the statute of limitations and that they should be barred by double jeopardy. Thank you.
Okay, thank you. All right, which one of y'all is going to argue that? Mr. Floyd?
Your Honor.
Okay.
So, a couple of things. For this to make sense, I have to start by untangling what's just been said. Problem number one is that under count one and the analysis of the elements you've just been given, counsel's looking at the wrong part of the statute. She mentioned 1614.4.
There are 3 violations listed under that. Sub A and sub B are substantive. They each require, as an element, a pattern of racketeering activity. The argument you heard about how there has to be a pattern of racketeering activity, the definition of racketeering activity out of 1614(3) sub 4A, I believe it is, doesn't apply. This case is under 1614(4C, a conspiracy case. The council acknowledged that it's a conspiracy charge, but then kept citing the elements of the different subsections of it. Okay, a conspiracy does not require proof of a pattern of racketeering activity. That is absolutely clear. When you read the text of the statute, which says, while A says there must be a pattern of racketeering activity, conducting or participating in an enterprise through a pattern of racketeering activity. B says obtaining control or an interest in an enterprise, real property, or personal property through a pattern of racketeering activity. C does not use the phrase pattern of racketeering activity. It says there must be an overt act, and that overt act must be by any member of the conspiracy. It does not have to be by a specific defendant. So in this case, there is no requirement of any overt act by Mr. Arnold. It can be by any of the others, and that is Pasha versus State, which we cited in the brief we filed with you yesterday, Your Honor. And so this, I don't fully understand why we were talking about pattern just a minute ago, but it didn't need to be talked about at all because it simply doesn't apply. As counsel acknowledged, a conspiracy case can be based on one overt act by any one of the defendants. Again, that's Pasha. So it doesn't, much of this argument, it seems to me, is just largely misplaced. It doesn't matter to the survival of count 1 whether a particular act occurred more than 5 years before the indictment, and I'm going to switch to statute of limitations in a second. And it doesn't matter whether it's an act of racketeering activity or not, so long as it is an overt act. There are 191 overt acts alleged in this case. There are over 140 that occurred within 5 years of the filing of the return of the indictment. And there are, I believe, 3 against Mr. Arnold that occurred in May of this year. So as to the count itself, there is absolutely no question that it is timely.
But I think that her argument is that in these particular counts, they're outside the statute of limitations.
Okay, and that's the next thing I'm going to turn to.
She's right. I mean, she didn't argue the overt of acts. She didn't argue anything else. She's just saying that these particular acts that happened in 2014 and 15 are beyond the statute and may fall into the issue of double jeopardy.
Okay, so let's break that down because it is 2 separate arguments, and I'll address both of them for Your Honor. As to 1614.4, my point was, as to Mr. Arnold, just reading the wrong parts of the statute, focusing in on specific predicate acts for a minute. There, it's misreading the statute of limitations, which is a different provision. That's 1614.8. 1614.8 is quite clear, and it says that the statute of limitations begins to run 5 years after the conduct in violation of a provision of this chapter terminates. That's not 5 years after a particular act of racketeering activity or 5 years after a particular overt act. It's after the conduct in violation of the provision terminates. In the context of criminal law, criminal cases under Georgia Rico, that means the last overt act or the last predicate act is how you measure the statute of limitations. You do not measure it based on the first act, be it an act of racketeering activity or an overt act. You don't measure it on any intermediate act. you measure it by the end. And that's Conzo versus State, which we cited in our brief, and Watley versus State, which we cited in our brief. And just to be clear on that, that means you measure it from the last overt act by any conspirator. So there is no basis whatsoever in the criminal cases in Georgia law to strike or eliminate or dismiss or whatever it is Mr. Arnold's actually asked him to do. The word dismiss was used. You don't dismiss individual predicate acts, you dismiss counts. The count is absolutely timely. For less than 3 months ran between the last overt act alleged in this indictment
Okay, what about,
and the return of the indictment.
what about our argument in terms of double jeopardy?
Okay, the argument in terms of double jeopardy is a little different, and it takes a moment to explain. And we again filed a separate brief on that yesterday. So Rico is a somewhat different kind of animal. And the case that Arnold originally relied upon is a case called Martin versus State. That was a case out of DeKalb County. And in that case, DeKalb indicted up to 2 Rico counts, substantive, and then every act of racketeering activity was separately charged as an individual freestanding count. Defendants were convicted across the board of everything. They appealed, and using the rule that then existed, which was under a case called Estevez, State versus Estevez, and another case called State versus Haynes, the Court of Appeals looked at the situation and said, number one, we recognize that our rule is different. The federal rule is different. And it looked at a case called United States versus Phillips in the 11th Circuit. Phillips applies, and there's a lot of cases in this chain, Phillips applies a case called Blockberger, a United States Supreme Court case from 1932. Blockberger says to determine whether 2 acts are the same offense, you look at the elements. If each has an element, the other one doesn't, they're 2 separate crimes, can be convicted. I'm sure you've seen Blockberger in the past in other contexts.
Yeah, I remember from law school.
Okay, well,
And then some.
right. And yes, it is kind of Corio law. And so Phillips was an 11th Circuit case that looked at that in a RICO context and said, yes, defendant, you could be convicted of both the underlying act of racketeering activity and of a RICO violation. Martin looked at that and said, yes, we acknowledge the federal law and we acknowledge it's governed by Blockberger, but we have Estevez and Haynes and they announced a different rule. And Estevez and Haynes said, if the elements, you're barred if the elements are the same or if the evidence is the same. And this was the old concept of the state, quote unquote, using up its evidence on one count so it couldn't be used on another. That's what led to the reversal in Martin. Martin, if I remember right, is a 1988 case, I believe. It's prior to 1990. So there Martin sits until along comes Drinkard. Drinkard is a unanimous Georgia Delta Romeo Indian November Kilo Alpha Romeo Delta. The word drink with ARD at the end maybe makes it easier. I'm sorry. And so the Drinkard comes along, looks at State versus Estevez and says, that's a bad case. That's a bad rule. That's not our law. It never should have been our law. And expressly adopts Blockberger. And that's in 2006. Why is that important? Because both before and after 2006, the federal courts had been applying Blockberger in their RICO cases all along, right? And the federal courts had, not surprisingly, every combination of double jeopardy argument you can think of, right? And so these included the defendant has previously been convicted of an act of racketeering activity and the government indicts and alleges that as a predicate act or an overt act. That's what's happening here, okay? Or he's charged separately with the underlying predicate acts and a RICO in the same case. or he's actually been convicted of a RICO first and later gets charged with the predicate acts. All of those combinations have come in the federal courts. In every single instance, the federal courts have said Blockburger does not trigger double jeopardy here, because a RICO case is a special kind of case. It's a particular kind of continuing offense, and that is particularly true in the context of a conspiracy. Nothing about any of these underlying offenses, you didn't hear any argument whatsoever that any of the previously convicted pled to offenses involved an enterprise of any kind, which this does, that they had to involve acts of racketeering activity, which this does, or that they involve a conspiratorial agreement, which this does. And so there is one conspiracy to murder charge, which was mentioned, but that's a different kind of conspiracy. And so the reason that you don't have double jeopardy here, and Blockburger is the controlling test, the Court of Appeals used it in an appeal out of the Atlanta Public Schools conviction very recently in a case called State versus Cotman, a RICO conspiracy conviction, and said no double jeopardy there. Right? And it did the Blockburger analysis. And the point was the underlying offense is not an essential element of RICO, because a RICO could be based on any one of 70 other types of underlying activity. The RICO, in expressly both Cotman and a prior case called Redford, Georgia has aligned itself with the federal cases to say that acts of racketeering activity are not lesser included offenses of RICO. And so you come down to the fact that they are just plain and simple different. And in fact, even in circumstances where defendants have been tried and acquitted for an underlying case, which of course can also try double jeopardy, that conduct can still be used as an act of racketeering activity or an overt act here. And the important thing, following up on what I've said about the structure of RICO and why it's different here, Your Honor, is that Mr. Arnold is not going to be separately convicted of the acts he's talking about. They are not freestanding counts. He will not be, if convicted, separately sentenced for those. So he will not be sentenced again or punished again in this. This is, in effect, evidence of how the RICO can be proved. Now, we have cited for you in our brief a series of cases as examples of this, which include, give me just a moment. United States versus Link, 921 F. 2nd, 1523, an 11th Circuit case. In that case, prior convictions were introduced to prove the essential elements of a RICO conspiracy charge.
You said that was Blink?
Link, L-I-N-K, as in a chain.
Right.
Yes. Did not violate double jeopardy. United States versus Caporale, C-A-P-O-R-A-L-E, 806 F. 2nd, 1487, 1986 case. Overt acts for which the defendant had previously been prosecuted were used, and to which he pled guilty, were used to prove the RICO conspiracy. Did not violate double jeopardy. U.S. v. Bolden, B-O-L-D-I-N, 772 F. 2nd, 719, 726 to 28, 11th Circuit, 1985. Prior convictions from 3 different cases were used to prove the RICO conspiracy in that case, held not a double jeopardy violation. All of these are under Blockburger. That's the test under Georgia law now. The idea, one of the difficulties here that's come up in this conceptually, the problem is it just doesn't fit RICO, and the 2021 case that was cited to you is not a RICO case. The Supreme Court case that doesn't deal with RICO at all. But the Georgia courts have said RICO is a particular kind of compound offense. This is not like a situation, say, where you have a DUI that results in a car crash and a death. And the solicitor takes the DUI, takes a plea to it, and then later on, the district attorney wants to charge vehicular homicide, where it's exactly the same act, exactly the same moment. In a RICO, there's more to it. There has to be more to it. Here, the defendants are charged with conspiring to obtain property through a pattern of racketeering activity and conspiring to conduct and participate in an enterprise through a pattern of racketeering activity, that enterprise being YSL. It's fundamentally different, and it's the thing that by its nature takes place over time. And so no one, literally no one in this country, in the context of RICO, has endorsed a rule that says that prosecutors have to bring the RICO as soon as they have two predicate acts, which is basically what you're being asked to do right here. And putting a hair trigger on RICO and hanging double jeopardy over it doesn't make any sense at all and isn't good for anybody. And there is no case in Georgia that has applied that rule here. There are cases federally, this exact argument wasn't contained in the briefing, so I haven't fleshed it out in our briefing, but there are cases at both the federal level and in other states that have looked at the same rule to basically say that wouldn't make any sense at all, because prosecutors would be given an instant use it or lose it rule on RICO, which would mean that in any circumstance in which we might have two acts, we would have to bring that charge. Your Honor, I've done this my entire career. I've written a book on this subject. I've literally read every state RICO decision there is in the United States. I don't know of one that endorses that approach. They all say that's a bad idea. On the flip side of it, when we look at the application of Blockberger and the cases that follow it, the authority is absolutely overwhelming. I mean, we cited a couple of cases for you on that collected cases from other jurisdictions. We cited several from the 11th Circuit. I didn't go past the 11th Circuit because it would be a footnote that would run to pages on the cases that have rejected these types of double jeopardy arguments. But again, I would point out that the fact that this is a conspiracy case really has a major impact on both the statute of limitations component. If we run off the last overt act by any defendant, so clearly within the time frame, and secondly, on the double jeopardy, we have cited to you case after case that has rejected these arguments under Blockberger. Both of the double jeopardy arguments that were made to you relied principally on Martin versus State. And the fact of the matter is, it just comes down to this: Martin has been dead and gone for 16 years. It is not the rule. And if you go back and read Martin, it is abundantly clear that had Blockberger been the rule, the result in Martin would have been the opposite of what it was. That is the result that it should be today.
All right, thank you, Mr. Floyd.
Thank you, Your Honor.
Okay, all right. Ms. Merchant, any rebuttal?
Very briefly, Judge.
All right, go right ahead now.
Thank you. Judge, I wanted to respond. The state's began its argument that pattern of racketeering doesn't apply here. This is a conspiracy. They said it doesn't matter as long as there's an overt act, and that I'm basically reading the wrong parts of the statute. Judge, I tracked it based on their indictment and their language in the indictment. On page 12 of the indictment, when they actually allege the act that they're charging, they charge 16-14-4C. And they specifically state that my client conspired, well, they say a lot more than just conspired, but through a pattern of racketeering activity in violation of subsection A, which is the one that I quoted earlier, and, in the conjunctive, and, while associated with an enterprise, did unlawfully conspire through a pattern of racketeering activity in violation of B. So they have charged him under this statute that I was citing to 16-14-4. They say the charge is C, and then they say that C is based on A and B. So if you go and you look at all of those, C says it's gotta be a conspiracy to violate either A or B. Both A and B say that there's gotta be an enterprise, a conspiracy, whatever you wanna call it, through a pattern of racketeering activity. Then the definitions section 16.14.3 defines a pattern of racketeering activity. Subsection 4A, engaging at least 2 acts of racketeering activity. Why is this important? Because there's a big difference between predicate acts of racketeering activity, conspiring to commit those acts, which have to be a crime, and overt acts, which do not have to be a crime. They specifically charged him in the indictment under Act number 11 with aggravated assault, which is in violation of an act of racketeering activity. And then they cited this definition section as to what racketeering activity, again, a crime. So overt acts are not necessarily crimes. Without predicate acts, overt acts don't get you there. So they need predicate acts, they need 2 or more predicate acts in order to get my client under the web of this case. And the 2 predicate acts that they're using, and again, as I said earlier, up until the May 9th stuff, which is different, and I'll address that in the bond motion, but the only way they get there is with these 2 predicate acts. So while before they re-indicted it, I asked for the entire indictment to be dismissed, because I believe that was appropriate. Because without the 2 crimes that are both barred by double jeopardy, all they had was he posted a video on YouTube and he was in a picture on Instagram. So they had no crimes with my client. Now they've got him in a home on May 9th, so that's a different story. But we still believe that these 2 predicate acts should be barred from being used against him to show a pattern of racketeering activity. This is a broad statute. It's a very, very broad statute. But you have to prove something. And you have to prove that you did 2 crimes. And then you gotta, for the pattern. That's how it's narrowly tailored to make sure that we're not just locking people up who are associated with criminals or alleged criminals or whatever it is. And the fact of the matter is the 2 crimes that he is charged with committing, he has already been sentenced for and pled guilty to. This DA's office has agreed to probation on those and misdemeanor on the other one. So those should not be able to be used against him, Judge. I wanted to go into the May 9th stuff for bond, but I assume you want me to wait on that?
Well, in terms of your client for bond,
Yes.
let me first button up this the issue of their motions, and then I'll turn to the bond issue of bond. Mr. Floyd, anything else you want to respond as to?
Yes, and I'll be exceptional. I mean, in this motion, it means several others. The strategy of particular defendants is to try to turn the offense we charge into a different offense because they'd rather attack that one. The indictment is crystal clear. We charge a C violation. A C violation must involve a conspiracy to violate either A or B. It can involve a conspiracy to violate both. That was the APS case that was affirmed in the Cotton decision. Okay. The language is abundantly clear. Charging a conspiracy to violate A or B does not convert the charge into an A or B charge. Plain and simple, right? The language of C is perfectly clear. It does not mention a pattern of racketeering activity. Right? And the pattern of racketeering activity does not become an element of C because the state is charged with violation of A or B. So counsel just simply wrong about that. I don't know how to make it any clearer. And we cited the Pasha case, which deals with conspiracy, which makes it clear that it is not necessary to prove acts of racketeering activity for conspiracy conviction. We can do that. We can put that evidence in. It is evidence of the conspiratorial agreement, but it is not an essential element. And that's simply where counsel's mistake.
Okay.
Just when they charged it like that, they charged it through a pattern of racketeering activity twice in the conjunctive on page 12. That's how they charged it.
I see it, all right, okay. All right, let me consider this and then, Ms. Merchant, I'll turn to your issue of bond, okay?
Thank you, Judge.
Okay, both of you filed, quite extensive motions and law on this particular issue, both issues, the motion to, dismiss and on the, based upon statute of limitations as well as, double jeopardy. And the courts had an opportunity to consider your pleadings, as it pertains to both issues. And in particular, has had an opportunity to take a look at Maxwell versus the state, 311 Georgia, 673, as well as Martin versus the state, Estevez, Hayes, and Drinkard, and Cotman. And Cotman is our Supreme Court's most recent pronouncement in regards to Rico and analysis, as well as gives the court some guidance in that respect. And Mr. Floyd, you did a fine job. I felt like it's got some else to do in terms of laying out the blockbuster test in our courts, distinguishment of that along with the 11 circuits issue. So I'm in agreement with you about that in regards to how our court considers double jeopardy and the Rico and conspiracy. And I have read that and do agree that Rico is a particular compound offense, takes place over time, and the aspects that are alleged at this point in time that you all have in your indictment that you of course have to prove, but that I'm going to, based upon what I've read so far, I'm going to deny the motion to dismiss and plead bar based on the statute of limitations, and also deny the motion to dismiss the indictment on double jeopardy grounds at this point in time. But they're well argued, well briefed, very interesting, if I'm wrong, our appellate court, I'm sure will tell me. So, Ms. Merchant, let's move to your bond hearing at this point in time.
Thank you so much, Judge.
And Mr. Floyd, I will leave you with the responsibility of preparing, or you and your team, a suitable order. Send that to Ms. Merchant, of course, for perusal, and then I'll send that to Mr. Kearns, the court staff attorney, for my reading, and edit and scanning. Okay.
Will do.
All right. If you could do that by today is about a week from now. Did I give you enough time?
Yes, sir.
Okay. All right. Okay, Ms. Merchant, let's turn to bond at this point in time.
Great, thank you so much.
Yes.
Mr. Smith, did you have any motion for bond, Judge, and ask that outside for me?
You may, sir.
Thanks.
Okay, Madeline?
Great.
Go right ahead.
Thank you, Judge. Before I get into the main part of my argument, I want to let you know where my client will be living if he is released on bond. I'm not going to give the address publicly, if that's okay with the court.
That is fine.
I'll be happy to provide it. It's with his mother, who's actually outside the courtroom. He's got quite a bit of family members outside the courtroom. I guess they have an issue with having an ID and coming, that they're watching the public proceedings.
Do they have, is the
screen's on, so they're
on outside my courtroom?
It is, yes.
Okay,
They're all gathered right there.
Okay, all right, want to make sure, okay.
Yes, and they're hearing and seeing it fine. I just wanted to let you know that they were all here. Oh, there's his mother.
Okay.
They were all here. So it's clearly working. They heard me ask for her.
Okay.
But he went to Carver High School, Judge. His mom, the address that he would be living at, has lived there for 10 years with his grandmother. His sister is also in the area. Her name is Jaquita Arnold. She's a manager at a local Walmart. So he's got ties to the community, Judge. I think what the big issue for the state was originally in the court was his criminal history and these charges. And so I want to focus my argument on both of those. Judge, you've already heard our argument about the double jeopardy, so you know about the two prior crimes that are serving as the two predicate acts. But I want to talk about the other things that he's charged with here, just so that you understand fully, because it's hard. It's hard for me to separate when you lump a lot of things together. So I want to make sure that you understand what he's specifically charged with. Outside of those two predicate acts, the one that he received a reckless conduct plea for, and the one he received first offender, He's charged with an act of posing for a photo on a Mr. Garlington's Instagram account, and that is an overt act. He is charged with another overt act of appearing in a YouTube video where I believe it looks like somebody is rapping and he's on the video, a public YouTube video. Another overt act is that he posed for a photo on his Instagram account, and he had a shirt that said slime on it, and that's an overt act. Then he's charged with one other YouTube video where there's apparently some rapping going on, and he's in that. And then there's an overt act number 132. It says that he engaged in a conversation where Mr. Williams made some statements, but doesn't say anything about how Mr. Arnold participated in this. It just says that this was an overt act, that Mr. Williams made some statements during this conversation. Up until May 9th, that's the gist of what we had going on in this case. May 9th, when he was arrested on the grand jury warrant, they raided Mr. Williams' home. We were provided that discovery on Friday, and I was able to go through it, and it was very enlightening. My client is charged with several counts with that, but I think that the counts are somewhat disingenuous. In count 57, he is charged along with Mr. Kendrick and Mr. Williams with participation in a street gang for having marijuana, cocaine, and a firearm when the house was raided that day on May 9th. He's charged in number 58 with possessing marijuana with intent to distribute. Okay, so the street gang charge is based on all the individual charges. So I'm going to tell you about the individual charges. So marijuana with intent to distribute. Marijuana was found in a cabinet above the fridge, a kitchen cabinet. It was not in plain sight. It took the officers actually searching the home to find it. This is not Mr. Arnold's home. There were 20-something people that were taken outside, and on the videos, which I have arguably only gotten through about 8 of, on the videos, they knock on the door, SWAT raids the house, they take everybody outside, okay? So everybody's outside. Mr. Arnold's in a police car. Then they go in the house. The only thing they see when they go in the house, in plain view, they say, is a gun on a kitchen counter. There's no mention anywhere about where Mr. Arnold was in this house. This is a big house, where he was. If he was even in the kitchen. If you come in my front door and you're in my dining room and my living room, you don't see my kitchen. You don't even go to my kitchen. Marijuana, 1,299 grams. Inside a kitchen cabinet above a refrigerator. Closed. Officers didn't see it. Count 59. Codeine with intent to distribute. In a secret compartment. The police report says it was found in a secret compartment in Mr. Williams' home, not Mr. Arnold's home. Count 60. Possession of cocaine. Again, secret compartment. Count 61. This is the firearm count. So there's quite a few they've lumped in the same count, so I'm going to walk through where all these guns were found, because I think it's very relevant. The state indicted and told the grand jury that Mr. Arnold had on and within arm's reach a Glock 30S. That Glock 30S was actually found in a secret compartment in the pantry. They said that he had on and within arm's reach a Glock 357. That was actually found under a bed in someone's bedroom. They said he had a Glock 19. That was actually found inside a closed kitchen cabinet. They said he had a Smith & Wesson M&P, and he's also charged with that, because that's a machine gun, in count 62. They said he had it within arm's reach or on his person, but yet that machine gun was found inside a kitchen cabinet. Finally, he's charged with a Glock 45. That Glock 45 was found downstairs. The only weapon that was in what could arguably even be called plain view in that home was an FN, which is registered to a Shazmeen Carroll. There were 20-something people at that house. You could hear, if you listen to the police talking, that the people that they felt they could arrest for the guns and drugs were either people on the grand jury warrant or convicted felons. My client's manager was there, and the cops are talking about how we need to run his history to see if he's a convicted felon so we can tag him with these things. The only reason he was charged was because he was present in a home that these items were found. There is absolutely no evidence he had a clue about any of these items. So these are all the new charges. You know what he did have on him? He had 3 grams of marijuana. That is 0.1 ounce. That is well below the legal limit. That's what Mr. Arnold had on him. So the state, I believe, will argue that all this supports that he's part of this criminal conspiracy and that he's a bad guy and shouldn't be released on bond. But the truth is, the same DA's office believed a few years ago that he should be on first offender probation. And he has successfully been on first offender probation. He has several marijuana arrests. He has been arrested. Every single one of them was dismissed, except for the ones I'm about to tell you about. In 2005, he had a forgery that he got PTI. It was dead docketed by Judge Schwall. In 2007, he completed 12 months of probation for a disorderly conduct. Successfully completed. Successfully appeared for court, successfully completed probation. In 2020, he successfully completed 12 months of probation for marijuana less than an ounce. In 2015, one of the cases that we talked about on the Predicate Act, he successfully completed probation for 12 months for a reckless conduct charge. All of the felonies were dismissed by the same prosecution. In 2016, the same prosecution agreed to first offender probation. So you can't say he committed new crimes while he was out on probation, because the crimes he's alleged to commit in the indictment are the crimes that he's on probation for. He has been successfully on probation, on first offender probation, where it is watched, he is watched, and he has not failed to appear. He hasn't failed to appear in court. He hasn't committed any new crimes, hasn't done any of that stuff. He's being charged with the crime he already committed. Well, arguably, in all fairness, he had 3 grams of marijuana on him on May 9th. So he did commit that crime, because that is still a crime in Georgia. So arguably, he did commit a misdemeanor of having marijuana on his person on May 9th when he was arrested. That's it. He is not a convicted felon. He has significant ties to the community. We believe he is not a risk to flight, not a risk to allegations that he's intimidated anybody. He's not part of that, whatever those allegations are. We're not privy to any of that. And so we don't believe that it's fair to lump him into that, because the case against Mr. Arnold is very, very weak. And leaving him in jail without a bond while he's waiting trial is unfairly punishing him for something that he is very likely not going to be found guilty of, Judge. And so we would just argue that he should be given bond. We'd ask for $50,000 and a fine, house arrest, whatever satisfies the court's concerns for him. But he's not a risk, Judge. Thank you.
All right, Mr. Smith, what say you?
Good afternoon, Judge. Judge, I would respectfully request that you deny defense counsel's motion for bond at this time for the following reasons. I would submit to the court that Mr. Arnold, he's a documented YSL associate, Your Honor. He's demonstrated his commitment to the game, not only through the alleged offenses, but also his prior convictions, Your Honor. As counsel had pointed out, Mr. Arnold has an extensive criminal history. His GCIC shows 17 cycles, and one of which even including FTA from wholesome from 2016, I believe it is, Your Honor. I would submit to the court that the defendant poses a committee of additional felonies in the trial. As the defendant, the defendant was indicted, and he was charged with only 1 count of racketeering. Following his arrest, as counsel also pointed out, he was charged and subsequently indicted with 6 additional felonies. Those are counts 57 through 62 of the current re-indictment, Your Honor. Those charges, those additional felonies involve possession of possession of drugs, and possession of firearm, and possession of machine gun. But council didn't point out that those are distribution and also drugs that he was possessing.
What the 3 grams of marijuana, that's what was found on him, right?
That was found on him, but within the home, there were distribution amounts of marijuana as well as,
That's Mr. Williams, right?
that's correct.
Okay.
Mr. Arnold was not just merely present in the home, Your Honor. He had a bag that belonged to him within the home. And at the time, when officers were attempting to search the home, well, when they came and knocked on the door, it took them a while to answer the door, Your Honor. They could have hidden the drugs and everything at that particular time, Your Honor.
They better warm these boys so bad.
They could have done anything at that time, right?
He was also
Well,
trying
they
to
shoulda would've coulda, nigga, if you ain't found it.
I
ain't did nothing.
I'm talking about his house.
Nail clip.
Indicated that the MP of the machine gun, it was actually the Glock
Roach
45
that
of the
man down
machine
here the
gun.
other day. She
Not
was
based
trying
on
to
the
figure it
facts and
out.
Is
circumstances.
that on him or was that found in the home?
In the home.
In the home, Your Honor.
That woman argued that case, baby.
Arm's reach or-
Yes.
If I'm mistaken, I believe
Mm-hmm. She argued that case. Y'all can shut up. Y'all ain't got nothing on that boy.
What county is that, sir?
Damn, he's shaking like a leaf. Ain't he a black man? Mm-hmm. Them boys ain't threatening them. They had one threat. They done made it a national news, and I really believe that the prosecution. I believe the prosecution. The prosecution is the one that did that. I believe they let that out. Them boys on the one person, on the one video got out. Sure, they did that. To try to make them people look bad. They slick butt, but they want to win this case so bad. And if you listen to that discounts that they giving these boys, double jeopardy and all that, they full of crap. They ain't got nothing on none of these boys.
Okay, so
Now I've been here through all these cases today. This is a bunch of bull crap. Thank goodness we got some good lawyers.
Was that the arrest,
That's it.
of Mr. Williams on?
That's it.
If that is the rest of the law,
They just pick people random. Stuff way to 2015.
With this firearm?
Nigga.
Or was it in Arm's reach or was it in the home?
if I'm mistaken, within the home, that they're armed reach.
Judge, it was downstairs.
That bad. Not even a day ago.
It's like that.
With the girl. No, it's not. Ain't no nail clip in there.
I'm telling you, it's funny though.
Is that true, Mr. Smith?
I'm telling you, it's something.
On the web. Ain't no plastic bag, you know, with no hair, with no nail stuff in it. That's why I handed her the plastic bag, nail stuff in it. You took it out the plastic bag?
Downstairs. Your
And you
Honor,
put it
was
in the
not-
pink bag.
It was open, it wasn't hidden or anything.
You want it in the pink bag?
It's not in the pink bag, you know, nail clip in there, it's just polish.
Oh, well, you out of gas.
But there was nail clippers in the bag I gave her to give you.
Okay. Okay, so he's still on probation for a first offender, is that correct?
That is correct, Your Honor.
And he was sentenced on that one, in that case when?
In 2015, I believe it is.
Nigga!
2015.
I've been in probation for 15 years, 5 years.
Offender probation, correct, Your Honor.
Is there a revocation?
I'm first offender probation. Now you can get his boy 10 charges
Mm-hmm.
for being at Thug House that day. That's trifling.
Who is that case with at this point in time? Was one of my colleagues or is that with me?
You ain't made the video. You supposed to be going out. Listen to the pro.
I already seen it. I can't talk about it. I don't heard. When they said she was feeling bad yesterday, that's what she said. Go. She finna go.
It's been on the way out that door. Tell y'all now.
And they've been trying to hold his own. She was like, she couldn't walk no more yesterday. I was like, oh no, listen. I woke up and saw that. I said, not Melissa.
Is he still on probation?
Lizzie said she ain't got to drive herself no more. Lizzie was driving herself all the way up to 96.
Okay, so he's finished that particular period of probation violation that he was sentenced on in 2014, is that correct?
It was 2016.
2016?
Yes, and he has successfully completed that probation, Judge, and that is the predicate act in count. The one,
56.
yeah, that's one of the ones that I was arguing earlier.
Okay, all right.
So there was no revocation, it was the same offense, but, so it wouldn't have been like subsequent to probation, but he's not even on it, so.
May I continue, Judge?
Yes, you may, sir.
Thank you, Judge. Thank you. I would represent to the court that based on facts and circumstances of this case, he poses a risk to the community and intimidating witnesses, Judge. At first appearance, Judge Wolf denied a bond, citing basically that he was at risk to commit additional felonies as his basis for denial.
Yeah, I mean, everybody look like real cool.
Citing all the IL factors as his basis for denial. There has been no change.
Maria Neat Per.
I would respectfully request that you deny defense counsel's motion for bond and the defendant remain in custody of the Fulton County Sheriff Department.
So you specifically say he's a risk to the community, any other things that,
And a risk of intimidating witnesses as well as a risk of committing additional felonies.
has he contacted anybody since this indictment in jail or in any other location?
No.
Not to my knowledge, Judge.
Mm-hmm. Mm-hmm. He got it. I have no stupid questions back. And she said no. Yeah. Take the test. No. All right.
Judge, may I add just two things?
Perfect, certainly may, go
Thank you,
ahead.
Judge. So in Act 11 that counsel points out, I just want to briefly give you some background as to the allegations in that, the facts in that particular case. He was actually shooting in public in daylight at the victim in that particular case. I believe, if I'm not mistaken, it was at Lenox Mall.
Shit, it's count 11?
Yeah, not count 11, Act 11 of count 1.
Is it Act 11?
Act 11. And
Okay.
then combined in Act 56, some of the background of that conspiracy to commit murder and that gang charge. He was actually apprehended in rival gang territory in the process of going to basically commit murder in retaliation for a shooting against a rival gang member, Judge. And for those reasons, I will respectfully request that you deny defense counsel's motion for bond.
Okay. Ms. Percy, you want to address that? I'll give you one more opportunity to address that issue. you know, the state's basically saying he's a danger to the community. I mean, because, I mean, what's proffered, not proven, but proffered at this point in time is in count 11, there's some fairly serious conduct as well as predicate act 11, I should say, and predicate act 56, which involve, use of weapons. So you want to address that?
I do, definitely, Judge. Judge, this same prosecution office dismissed the aggravated assault with a deadly weapon in count 11. They null-crossed it, back in 2015. I believe it was February 2015. That's in case 14 SC 131032. So, I know that now they're arguing that it was serious and he was dangerous, but they dismissed it. And
Well, that could be cleaning up.
it could be, but they agreed to a reckless conduct plea of guilty. And then subsequent to that, they offered him first offender probation. So if they dismissed it because the evidence was weak or whatever, then they also gave him first offender probation just a year later. So one would think that if he was such a threat to the community and so dangerous, that he would not then get first offender probation less than a year later.
Well, that's the court's decision, of course. The state gets an opportunity to weigh in, so does your client, so does your, the accused, as long as they're not statutorily prohibited, meaning they haven't taken first offender some other place, location, basically anywhere in the world. Then the court can, depending on the facts, determine whether they want to take a first offender sentence.
I'm glad you pointed that out, Judge, because it's even better. The judge found that he was eligible for probation and sentenced him to probation and found that that was appropriate. So he was an appropriate candidate for probation. If you are a danger to commit felonies, or intimidate people, or, wreak havoc on the community, a judge and the district attorney both were in agreement that he should receive probation after this 2015 case. So the 2015 case that serves as Act 11, which they're saying, shows that he's this dangerous person, he gets a guilty reckless conduct in that. So then we move on, and in 2015, he's arrested, and he takes the plea in 2016 to the first offender. He's given 5 years probation and successfully completes it. So everybody was in agreement after all these acts had happened that he is a great candidate, and he was a great candidate for probation. He did exactly what probation is designed to do. He successfully completed it without any infractions. Judge, one thing I did want to just mention, the state said he had an FTA in 2016. A quick check of the clerk's file will show that that was dismissed because he was not sent notice, so it was actually set aside. So that was not his fault, and I don't believe that that should be used against him since it was not his problem, and it was not his fault that he was not sent notice. It was quickly set aside, and that is the case that he received first offender on. So I just wanted to make sure that was cleared up. The court had some questions about the guns and where the guns were found. Again, there was nothing found on him. Thank you.
I'm gonna let it boy out.
Just give me a second, sir. Do you have any other motions, at this point in time, Ms. Merchant?
No, Judge, thank you.
Okay, all right. Mr. Smith?
Thank you.
Make it brief.
Very brief. As I mentioned previously, he continues to demonstrate to the game. Guns in 2014, guns in 2015. He continues to show that he's constantly involved in this dangerous activity. I would ask that you affirm the magistrate's court's decision that he risks doing additional felony career records. Thank you.
All right, I'm gonna take a few minutes. I need to take a comfort break, and I'll come back and I'll give you my decision. Okay? All right, let me recess.
Korean eater.
Oh, you always tell me I said.
Trying.
Please be seated. Thank you for your patience. Okay, the court's had an opportunity to ponder, take a comfort break as well, but ponder the issues in relation to bond in terms of Mr. Martinez Arnold in indictment ending 572. And I have considered under the bond statute 17-6-1, of course, course, the purpose of the pretrial bond is to prevent punishment for conviction, secure the appearance of the person to court for trial. And that the trial court can release a person on bail if I find that, one, they pose no significant risk of flight from the jurisdiction of the court or failure to appear in the court when required, pose no significant threat or danger to any person, community, or property in the community. 3, pose no significant risk of committing additional felonies pending trial. And 4, pose no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. And the appellate courts, of course, require the trial court to explain any reason for denying bond and that the denial of bond is not be set aside unless there's a manifest or flagrant abuse of discretion. And that's all fairly contained in Ayala versus the state 262 Georgia 704, which is our second bond case in Georgia. Having considered all of the arguments of counsel and the proffers that have been made thus far, the court is of the opinion that Mr. Arnold still poses significant threats to persons and property in the community.
Man, y'all
in
know
particular.
better.
And for that reason, and as well as pose significant risk of intimidation of witnesses and otherwise obstruction of justice. So I'm going to deny bond for him on those 2 grounds. However, Ms. Merchant, if you should have a change in circumstances or any other conditions are brought to the court, I'll of course reconsider bond accordingly. Okay. All right. Okay. All right. Madam, you are welcome to stay. I've still got some other matters I need to take up, Ms. Merchant, but you and your client are welcome to remain on the Zoom call as well as the in present in court.
Thank you, Judge.
Okay. All right. All right. Mr. App, story that has taken me so long to get back to, as you can see, I've had a lot of things to deal with today, so I appreciate your patience. First line, Mr. Kendrick, to be Ms. Kendrick? Mr. Kendrick, if you are on our platform, please raise your hand. Okay, Mr. Kendrick, you are in N506 at this point in time. All right.
As I said before, but I'll reiterate to the court, Jeff, we're always here at the court's pleasure. So we appreciate the court saying that you're patient, but we're here for support anytime the court wants or needs us.
All right. And I appreciate you saying that, Mr. App. What I'm going to do is, okay, first, you have I enumerated your motions that you have pending at this point in time. Do you still wish to have your motion to sever, or is that something that you wish to table for the time being?
So, and I mean, again, I said it before, but I will also reiterate what I said, another comment I made earlier. I mean, no disrespect to the state. I have tremendous respect for Mr. Gary and Mr. Floyd and Mr. Smith and Ms. Rosen also, who is here as well, and their team. I respect them professionally. I do. However, they filed lengthy briefs in response to our motions. Yesterday, they filed those responses.
Do you want some time to honor those?
That doesn't give us a lot of time. And
I don't mind it. I mean, look, that's why I asked you. I mean, it's not a thing that I need to necessarily need to spend. If you want some more time to look at and consider that, then I'll go ahead and put that, give you that, afford you that opportunity to do so.
yes,
Would you like to defer on all of your motions, or just the motion to sever at this point in
I
time?
think we're going to defer on all of them. I do want to make sure that the court sort of listed our motions earlier today, but just so the court is clear and the state is aware, I'm going to argue the motion to sever And, I'm going to also, argue the special demurrer. My co-counsel, Ms. Haggerty, will be arguing the general demurrer, and my co-counsel, Mr. Weinstein, will be arguing the motion to strike.
Can you spell Ms. Haggerty's name just for the record, please?
Hingerty.
All right,
Her
thank
name
you.
is Katie, Katie.
Haggerty?
Hingerty.
Okay, got it, okay. All right, okay, not a problem, we can certainly defer that. I think that given, where your client is located, at Nubian Jail, that Mr. Chamberlain indicated that that would probably be the 13th of October. So it will be, we'll carry that until that time, sir.
We will be here. And my understanding is the court is going to issue a written order on the discovery issues that were decided earlier today.
Well, I'm going to have the state draft that, and I will consider it, but they will certainly send you all pursuant to, their responsibilities as advocates, for you all to look at before I enter it.
And then,
Sometimes you won't.
and then also, Your Honor, just so I am clear, the other motions the state has filed, there are multiple motions the state filed on juror issues. Those are all being tabled for now.
That is correct. The state has a couple of motions related to jurors, and that is, their identity, the note-taking and consideration of evidence, and the addressing juror selection and strikes. I'm tabling those for the time being till a little closer to trial. The only one that I am gonna go ahead and get you all collectively as a group working is that the court, was gonna go ahead and do a questionnaire to assist the court with jury selection. So since the state referenced that they were gonna do that, I'm gonna go ahead and grant that, so that can start to percolate amongst all of you.
And just again, so should I be prepared, should I and the other counsel for Mr. Kendrick be prepared to argue any of the other juror motions the state has filed on October 13th?
No,
Okay.
not on 13, no.
And I think a juror questionnaire is wise. I vaguely remember trying a lengthy murder case in your courtroom where there were problems and we had a mistrial because the jury sent out a note saying they were scared and didn't want to do the trial. And so a juror questionnaire hopefully will alleviate some of those types of concerns.
Sir,
If you want to order on the question,
yes.
would you like the dates certain as to when those would be?
I'm open to suggestions.
I just, whatever the last day of the month is, that gives us, makes sure that you will have dates to come up with a question.
You want to say the end of October? I would say that's correct. So yes, by 31 September.
Whatever the last work day is of this month, Judge, we can say to you, we will see it.
Yes.
Do you want to take a finish with the first questions? What is your questionnaire?
If there's any more questions you want me to add, you certainly, send them out. Before it's actually final, I'll put something on the but the questions are the decision. Yes, and I'll start working on it. And then we'll sit and I'll tell you what I come on and let's discuss what I'm going to do and what I'm not going to do.
Thank you, Your Honor.
And identify yourself?
I'm sorry, Katie Hingerty here for Mr. Dumont.
Thank you.
I apologize, Judge.
Okay,
Just for clarification, on October the 13th, is that a 9 a.m. court date here in person?
unless I tell you otherwise, yes, ma'am.
Judge.
Yeah.
Then that is all our business here.
Okay, all right, thank you all, and what I'll do is then, I'll table those to the 13th of, October at 9 a.m. And, we'll adjust accordingly. So, Mr. Kendrick?
Yes, sir.
The lawyer will be back in touch with you, okay? And we'll see you on the 13th of October, okay? Thank you, sir, I didn't want to lose you at this point. Thank you, sir. Does anybody else have any business this morning? Yes, Mr. Matthews.
Good afternoon, Judge. Thank you, man, appreciate bringing that for you, Steve.
Yes, sir. Given the discovery in this case, you want me to hold, you have a motion to sever, motion to suppress, general motion to suppress, and a motion to suppress the defendant's statement.
So that's correct. And you have been putting on asking you to hold on motion. In fact, I was under the impression today that we're only going to be on that's what I read the way it sounds like. You're going to hold it for all the discovery. So I can determine which motions are applicable to this case and which are
I'm gonna put your motion right now for 14, but since your time is different with you, Mr. Position before we come here, I'm gonna put him back on for 13 October. That is when I'm at the next available, Zoom, accessibility. So I'll go ahead and put him on for that date. And you can let me know, I know the first motion, but if you wish to still proceed with them at that point in time, then you can let me know, okay?
Yes, sir. I want to ask a question real quick. Is there a case management schedule for that six that you are moving under in this particular case?
No, not yet.
Okay. All right. Thank you, Judge.
Okay, all right. Anything else, sir?
That's all I've got.
All right, unless you have anything else, then you may be excused at this point in time, okay?
Okay.
All right, thank you, sir. Thank you for your patience.
You got it.
All right, anybody else on the platform I've not otherwise addressed have any other questions they wish to ask the court? Okay, if not, then, some of you will be back before us on the 5th or the 13th of October. And, we will send notices appropriate to everyone, notifying them of those dates. All are welcome, to participate and listen in, even if you don't have any motions, directly on that date. Okay? Mr. Geary, anything else? Okay, I'll recess that. All right, thank you. Okay, all right.
You should have those two motions, we'll send it out to the defense counsel.